Justice Gorsuch.
General, just a few questions following up on the major questions discussions you've had. You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit? To lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now. In 1790,
isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying we shouldn't be concerned with. Yeah, I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute, again, that has a whole.
I'm not asking about the statute. General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions and non-delegation, what bite it would have in that case.
Yes, I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale abdication of.
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply, at least.
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential.
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would.
Well, you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now you're. I think you. Tell me if I'm wrong. You backed off that position.
Maybe that's fair to say.
Okay. All right.
That would be, I think, an abdication. That would really be an abdication, not a delegation.
I'm delighted to hear that. You know. Okay. All right. And then I wanted to return to something Justice Sotomayor asked under this statute. Okay. So now we're in the statute. It's a major question, though. Could the president impose a 50% tariff on gas-powered cars and auto parts to deal with the unusual and extraordinary threat from abroad of climate change?
It's very likely that could be done. That's very likely.
I think that has to be the logic of your view.
Yeah, in other words, obviously this administration would say that's a hoax, it's not a real crisis, but...
I'm sure you would.
Yes, but that would be a question for Congress under our interpretation, not for the courts.
All right. And then on this inherent authority idea, I understand the president's inherent authority in wartime, and a lot of your examples of regulating commerce, and maybe your best one, Hamilton, during the Civil War, they occurred during wartime when the president's commander-in-chief power is clearly in play. Does the president have inherent authority over tariffs in peacetime?
No, we do not contend that.
Okay.
And in fact, I'd cite, if I may, I'd point the court to two cases. They're Loving against the United States and then Masery that cited in Loving.
And counsel, Algonquin wasn't a textualist opinion. Do you agree with that? In other words, the analysis that the court was using there was really keyed to the legislative history of that statute, and it wasn't as though we were doing an interpretation of the word adjust.
I disagree with that. I think you read the opinion, first it talks about plain meaning, then it talks about statutory context, and then it goes on to legislative history, so it was all three of those. And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth.
All right,
the court said, no, Congress is not bound to use that particular formulation when it wants to confer this power.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect for Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEPA in making this argument, because as I understand it, that the IEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor's statute, TWIA, and it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that, because what Congress actually did as—
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the actions the president may take when it comes to this particularly narrow domain, which is, various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEPA that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language in IEPA.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain presidential authority in this area?
To constrain it in the triggering conditions and the procedures that apply in this—
So those are the triggering context. The triggering conditions and procedures that apply are a means to constrain. That is how they went around about constraining. But my point is that Congress enacted this legislation with the intent of preventing the president from having unlimited powers in this area, and you're asking us to now interpret that statute consistent with an understanding that Congress wanted to allow the president to do pretty much whatever he wanted in this area.
Congress took the language from TWIA and enacted the very same language, and most importantly here, the very same phrase, regulated importation, in IEPA. And therefore, the natural inference is Congress did not intend to change the scope of authority, the powers, the tools the president can exercise.
Did any president under TWIA use that language to impose tariffs?
Well, yes, President Nixon's 1971 tariff.
Not a tariff. That wasn't a tariff. It was a licensing agreement during wartime. It was a specific thing. A tariff I'm talking about.
I'm referring to President Nixon's 1971 tariff.
I'm sorry. Excuse me. Yes, I thought you meant Lincoln.
Not only that, but then it was upheld by the Court of Appeals with exclusive jurisdiction under this very phrase.
Can I back you up just a second? I'm sorry. You're talking so quickly.
Sorry.
President Nixon did not rely on TWIA initially to impose the tariffs. Is that correct? I understood that was just a litigating position that he took once it was challenged. That was not his initial.
I wouldn't put it that way, because he has a broad invocation. I'm invoking all range of statutes, something like that, in Proclamation 4074. And I think the understanding is he didn't want to kind of spook our allies by invoking the Trading with the Enemies Act, by specifically invoking it. But in litigation, it was defended on that ground. So the Department of Justice defended it as an exercise of TWIA and did so successfully.
I want to make this clear. I think the Supreme Court is definitely going against Trump. They're losing this case 100%. The three liberal judges, look, tariff policy isn't always strictly left or right. There have been left-wingers who were more pro-tariff, right-wingers who were more pro-tariff, left-wingers who were more anti-tariff, and right-wingers who were more anti-tariff. This is not a strict left-right dichotomy. But in this case, the three liberal judges, I think, both dislike the policy itself and how Trump implemented it. It's too dictatorial. Trump does have the power because Congress, like a coward, basically surrendered its authority on the tariff question. But they're essentially saying that what Trump has done and how he's done it completely goes against the good faith interpretation of implementing tariffs and related policies. And the conservatives, I think, largely agree, but they also, from a capitalistic perspective, don't like it. There's a war within the GOP. Capitalism does not require free markets. I want to make that clear to people. Capitalism is about the extraction of value from workers. What makes a capitalist isn't that they sell something. It's that they make money by having other people work for them, taking a portion of their labor value and multiplying it. They pay you $10 an hour and make $11 an hour off your labor. That's where the capitalist makes money. But trade existed long before capitalism. Trade has existed for thousands of years, right? And so, some capitalists do love trade. The Reagan wing of the Republican Party, say what you will about them, did not like tariffs, especially tariffs like these. And many of these conservative judges are probably more influenced by Reagan than by Trump. They might lean MAGA, but they're more influenced by Ronald Reagan's vision of the world than Donald Trump's. Look how old most of them are. The youngest one, Amy Coney Barrett, is still in her late 40s or early 50s. They're all older people, more Reaganite in mindset, and they're saying, Donald, we do not like these tariffs.